Welcome to Child Custody 101, an introduction to New Jersey child custody. Your children mean the world to you, and that means that right now you want to know, what are my options for child custody? What are my rights as a parent? Just as a reminder, this presentation contains general information and does not constitute legal advice. So be sure to direct specific questions about your own situation to an attorney. I'm Bari Z Weinberger, founder of Weinberger Divorce and Family Law Group. I'm a certified matrimonial attorney, and I have practiced family law for my entire career. I know this is not an easy time for you. I'm here to help you understand the child custody process in New Jersey and get you answers to your questions. Topics we will cover include the best interest of the child standard, legal custody versus physical custody, New Jersey court procedures, modifying your custody orders, and enforcing child custody orders, plus questions and additional help. So let's get started. When it comes to child custody, almost everything comes back to the question, what is in the best interest of the child standard? Here's what this means. In the context of child custody cases, focusing on the child's best interests means that all custody cases and discussions and decisions are made with the ultimate goal of fostering and encouraging the child's happiness, physical security, mental health, and emotional development into their young adulthood. Best interest does not mean that mom or dad is inherently better. In New Jersey, child custody laws are gender neutral. The law does not favor moms over dads. Parents have equal rights and responsibilities to their children. Frequent and continuing contact with both parents is presumed to be the child's best interests, but determining appropriate custody requires consideration of all facts. No form of custody is given automatic preference. How do the courts decide custody? This can be done either through custody agreements made between the parents or by court order, if the parents cannot reach an agreement. Courts prefer parents to make their own agreements, of course, about how to share parental responsibilities and parenting time whenever it's possible. Parents can and should work together to develop a schedule that fits the needs of everyone in the new structured family. To be upheld in court, parenting agreements must comply with the best interests of the child. This is always the overarching and underlying standard that all courts in New Jersey use. If parents can't agree on a parenting plan that meets the child's best interests, then the court will order a plan. According to New Jersey custody statute, whether the parents reach an agreement or the court orders a plan, certain factors must be considered in determining the best interests of the child. The factors listed in the statute are not exclusive. Courts have the ability to consider all relevant factors in determining best interests. What are the statutory factors? At least some of them. So first, safety. The court should consider any history of domestic violence, the safety of the child, and the parent's fitness. Court should also consider the emotional needs of the children. This factor generally focuses on the interaction and relationships of the child with each parent and siblings too, if relevant. Except in certain situations, the courts generally feel that the children have a basic emotional need to be in contact with both parents. The courts also consider the status quo. So think, before or after your separation, how much time did you typically spend with your child? And what was the quality of this time? The courts will take this information into consideration. So here's a tip. Start keeping a very basic log of the time you spend with your children and what you do during that time to demonstrate that status quo. The courts consider many other practical factors. They will want to know answers to questions such as, does the child have any special needs that would affect where they should live? What's the stability of each parent's home environment? How will schooling be affected if a certain custody plan is ordered? How far apart do the parents live? Do the parents work late hours or weekends? Or do they have erratic work schedules? What's the age of the child? And are there other siblings in the household? A child's preference for where they live can matter, but the child must be considered by the court to be of a sufficient age and capacity to reason. New Jersey courts do not recognize a specific age for this. They go on a case-by-case basis to evaluate the maturity of each child. A judge can interview a child with respect to their preference, but this is done in chambers, not in open court, to help avoid trauma to the child. Another factor considered is the ability of both parents to co-parent effectively. This refers to the parents' ability to agree, communicate, and cooperate in matters relating to the child. Parents demonstrate willingness to accept custody decisions is critical. Any history of unwillingness to allow parenting time that is not based on substantiated abuse will be examined by the court and weighed strongly. When making custody decisions, you will hear a lot about legal custody versus physical custody. So what's the difference between these two basic forms of custody? Legal custody governs a parent's authority to participate in big decisions in a child's life, such as major medical decisions, education, general welfare, and it includes schooling, religious upbringing, and medical treatment beyond routine or emergency care. Legal custody can be sole or joint, but joint legal custody is pretty much the default in New Jersey unless one parent is wholly absent or abusive or does not wish to participate in these decisions. Joint legal custody usually means parents make all the decisions together. In some cases, one parent will have the authority over certain aspects and the other will have authority over other aspects. Physical custody governs which parent child lives with. One parent can have sole physical custody, or parents can share physical custody. Sole physical custody usually allows for liberal visitation, what we call parenting time, with the other parent. Joint physical custody is considered shared custody when it approaches a 50-50 split, and there is also full sharing of parental responsibilities. Common custody arrangements include joint legal custody, which is again shared decision-making with one primary residential parent. Shared legal and physical, which means equal or near equal parenting time with equal responsibilities. This arrangement requires above average co-parenting skills on the part of both parents. Sole legal and physical custody is actually uncommon unless one parent is absent or abusive. You rarely see a court order sole legal and physical custody. In a joint legal custody arrangement, parents share decision-making authority for children's health, education, and general welfare. However, the parent a child is with at any given time makes day-to-day decisions in the child's best interests and notifies the other parent as appropriate. Let's say the child needs to go to the ER. The responsible parent makes the decision to go, but needs to notify the other parent as soon as possible. The child usually resides with one parent the majority of the time, while the other parent has a more traditional parenting time or visitation schedule. Even when physical custody approaches 50-50, it will not be considered shared physical and legal custody unless the parents also share parenting responsibilities 50-50. Shared legal and physical custody generally refers to a parenting arrangement where children spend equal or nearly equal time with each parent and parents share day-to-day parental responsibilities equally. Scheduling options usually include alternating weeks or splitting the weeks, sometimes alternating one day and night of each week to equalize at a time. This scenario requires a high degree of communication and collaboration. No bright line distinguishes true shared custody from joint legal custody with the primary parent, but the distinction can be important when figuring out child support. Lastly, sole legal and physical custody is fairly rare. The residential custodial parent is solely responsible for all major decisions, including health and education, as well as welfare. Some parents agree to this, but it comes about after a judge has determined that one parent is either completely absent or unfit due to a history of abuse or neglect or drug addiction or even some other type of similar issue. In the majority of such cases like this, the non-custodial parent will still have some amount of visitation or parenting time with the child, but this time may even be supervised or restricted to ensure the child's safety. What is parenting time? In New Jersey, child visitation is often called parenting time because a parent is really never a visitor, if you will. It's a more accurate description to call it parenting time. Are there restrictions on parenting time? Courts may impose temporary safeguards, such as requiring a third party to supervise the parenting time until that parent has satisfied certain requirements, such as completing a drug rehab program. In the most extreme situations, a parent may be prohibited from exercising parenting time entirely. However, this is not the same thing as termination of parental rights. Even if one parent has sole custody, the other parent may still be obligated to pay child support. The parent also retains the right to return to court at a later time and request a modification of the custody and visitation order if there are restrictions. In extreme cases where there is imminent risk of physical or psychological harm to a child due to parental abuse or abandonment, New Jersey DCP&P may take temporary out-of-home placement for a child's safety. A temporary custody arrangement ordinarily becomes a permanent one only if parental rights are terminated through a court process. DCP&P tries to provide parents with support. Termination of parental rights is viewed as a last resort. So now let's talk about the New Jersey court procedures in child custody cases. The courts first need to determine if they have jurisdiction over the child. Jurisdiction is based on where the child lives for at least 6 consecutive months. Once a state exercises jurisdiction, it normally keeps jurisdiction even if the child moves away. States can have jurisdiction over an absent child who resided in the state within the past 6 months if a parent or guardian continues to live there. Frequent moves in and out of the state can complicate jurisdictional issues. You want to avoid allowing a child to live with another parent out of state or county without a custody order in place. Do you need immediate help from the court? Well, you can file penente lite motions for temporary relief at any time during a divorce case. Temporary parenting orders may be necessary at the start of a divorce to protect the children and prevent one parent from making unilateral decisions. It also protects your access to your children. Temporary child custody orders are generally based on maintaining the status quo that existed before the start of any legal action. The court will absolutely require you to settle your parenting issues. There could be court-ordered parenting classes. You and your ex could propose a parenting schedule to the other and try to negotiate that, or there could be court-ordered mediation. There are set procedures for resolving parenting time disputes in the New Jersey Family Court. The court sends most cases involving custody and parenting time issues to court-mandated parenting mediation. Each parent proposes a parenting plan, and if the parents can't agree in mediation, then the case is put on a priority track to be heard by the courts. What information is contained in a parenting plan? Parenting plans become part of a court order, so they have to be followed, and at a minimum, your plan should include where the child is and will primarily live. Describe legal custody. Will this be shared or will it be sole? What is the specific time sharing schedule? Who has the child when? This should be included as an everyday arrangement and also include provisions for holidays, birthdays, vacations, breaks from school, and the like. Additional items to consider, including in a parenting plan, are things like access to medical records, report cards, teachers, parent conferences, and such. First rights of babysitting. So for instance, who gets to take the child if the other parent needs to leave for any reason? Responsibility for specific expenses and for sharing and unanticipated expenses. Responsibility for transportation of children to and from the parenting time. Designating a parent to take off work as a child is sick, or even for snow days. Means of addressing potential schedule changes or modification of a plan as the children get older. Agreement to attend mediation first before going to court, and any other agreements that you and your ex wish to include into the future, should there be a dispute or a need to make changes. So question, what if you can't resolve your parenting time issues through negotiation or mediation? Well, the court may want an expert opinion. So custody investigations and evaluations can be done through the family division or through private custody evaluations. A judge can order a social investigation or a best interest investigation of the child. The results will go into a report and ultimately be given to the judge. This may include a home investigation and inspection to make sure that the home is appropriate, a psychological parental functioning assessment, or a mental health evaluation if necessary. The judge can also interview the child, but again, in chambers, not in open court. In a private custody evaluation, parents can jointly hire a mental health expert to conduct the investigation and prepare the report for the court or parents, and they can each hire their own expert if they so desire. Whatever the case, child custody evaluation experts and those professionals must be neutral and follow uniform standards regardless of who hires or pays for them. A licensed mental health professional with training in child development and family systems can review proposed parenting plans in light of the best interest of the children. Think about choosing someone with experience working with parenting issues common to family reorganization. Private custody mediation is an out-of-court alternative. Mediation can reduce conflict and decrease the stress on everyone in the family. It's confidential and can keep your family matters private and out of the public record. Private mediation offers many additional potential benefits, including increased control over the process and the ultimate result. If you and your ex can work together, why have a stranger, the judge, come up with a plan for you? Private mediation can be started prior to filing a court case, so you wouldn't even have to go through the procedures if the two of you can come to an agreement through mediation. Private custody mediation is also a process that protects the children. Watching parents argue is traumatic for kids. It makes them feel pressured to choose sides and results in great emotional turmoil. Mediation helps parents preserve or improve upon the cooperation, relationships essential to co-parenting, which really is the goal. Parents who reach agreements on parenting matters in mediation often learn valuable skills that can help them resolve future disagreements that they might ultimately have. Even if serious parenting disagreements arise in the future, parents can often resolve them by going back to mediation. Post-judgment modifications refer to changes that may be made to a custody order that already exists. What if things change in your life after final custody orders are already entered? Child custody orders can be modified until children are emancipated, meaning they're deemed to be independent, or they get married, they're over the age of 23, they join the military. All changes or modifications require a substantial change of circumstances before a judge will change an order. Courts will expect parents to try to work things out through negotiation or mediation, as we talked about earlier, before going back to court. What is a substantial change? Some potential triggering events are an increase or decrease in parenting time, a change in the primary residential parent. So say one parent has residential custody and now it's another. A change from sole custody to joint custody or vice versa. Courts considering a request for a major change will require proof that the change is necessary to further the child's best interests. What happens if a parent of a minor child born in New Jersey gets a new job across the country and now wants to relocate? They can't relocate out of the state with the child without either a court order or the consent of the other parent. Under former rules, a parent could move if the parent had simply a good faith reason for the move and the move would not be harmful to the child. Under current rules, from the landmark case Bisbing versus Bisbing, a parent who wishes to move out of New Jersey must now show that the move is in the best interest of the child. The new rules also state that joint legal custody is now sufficient to trigger a full review and check for best interests in move-away cases. In the past, this wasn't the case. Now, if the parents share legal or physical custody or both, the move-away parent must demonstrate that it would be in the child's best interests for the court to allow the move out of New Jersey situation. The old rules were called the Bowers factors. If you come across move-away information that refers to Bowers, you're reading outdated information because the rules have simply just changed. Some helpful components that a move-away parenting time plan could include are: the child will typically be with the non-custodial parent during school holidays, such as winter and spring break, and for the majority of the summer break. The plan must specify a reasonable method of transportation for the child and allocate the cost of such transportation appropriately between both parents. And the plan must also specify additional methods of contacts, such as unlimited telephone calls, emails, texts. The plan must actually work for the non-custodial parent. If you don't want the child to move out of state, you must demonstrate that the move is not in the best interest of your child. To do this, focus on the closeness of your relationship with your child and show how the child would be adversely affected by your inability to fulfill current roles at a distance. What happens when the custody plans are not followed? What can you do to enforce child custody orders and agreements in New Jersey? Parents have a legal duty to comply with court-ordered parenting plans. This duty generally includes encouraging a child to spend time with the other parent. Parents must also refrain from making negative comments about the other parent to the child. Interference with custody or visitation includes subtle behavior like blocking telephone or email contact, or consistently scheduling a child's appointments and activities during the scheduled parenting time. Only in severe cases should you consider court action. Usually the better approach is attempting to work things out with the other parent on your own or maybe through mediation. If your child's other parent is consistently violating custody or parenting time orders, consider bringing both a motion to enforce litigants' rights and a motion to request a change in the parenting time arrangement. Interfering with court-ordered parenting time can be a crime in New Jersey. A parent who conceals a child from the other parent for the purpose of interfering with custody or visitation may have to actually serve jail time. What are the penalties that the court can impose for interference? New Jersey court rules say that in cases involving failure to comply with parenting time orders, New Jersey family law judges can order whatever remedies are justified under the circumstances. So it's pretty broad leeway that the courts have. A court may order temporary or permanent changes in the parenting plan, including some or all of the following: compensatory parenting time for the parent who lost the time, changes in transportation arrangements for the visitation, changes in the children's pickup or job relocation, or even a change in the primary residential parent. A court can also order the interfering parent to pay the other parent's attorney's fees and court costs, attending parenting classes and counseling, pay for counseling for the children or for the other parent, pay any costs resulting from non-compliance with the court order, participate in community service, or even comply with a warrant for arrest. It could be the case that imminent danger to you or your child led to the interference, such as violent behavior on the part of the other parent. If that's true, contact DCP&P, formerly known as DIFUS, the local police, and the district attorney's office in your child's county of primary residence to let them know your child's location and the details of what's going on so that they can take appropriate steps. If there's domestic violence, bring a custody action in an appropriate court as soon as reasonably possible. Contact an attorney or DCP&P immediately to ensure that you have compliance with the law. Be aware that non-receipt of timely child support payments is not a defense to holding back custody. So do you have any other questions? I'm sure that this raised a lot of issues and questions that you may have. Please feel free at any time to give us a call at 888-888-0919 or email us at info@weinbergerlawgroup.com. If you feel you want to speak to an attorney about your specific child custody or parenting time issues, give us a buzz at, again, 888-888-0919 and schedule your free legal confidential consultation to discuss your specific New Jersey child custody matter. Visit our website. We have more information there about child custody, all types of family law issues at www.wlg.com. That's www.wlg.com. That's like William, Larry, George.com. Or again, shoot us an email at the email address info@weinbergerlawgroup.com. Thanks again so much for being with us. We hope you learned something new. Please take care.